Hello, my name is Julie Rosenzweig. I'm an attorney practicing estate planning here in Lafayette, Louisiana. And thank you so much for tuning in and taking just a few minutes out of your day to learn how to keep your family out of court and out of conflict in the case that something should happen to you or your spouse or either of you passes away. So what we're talking about today is estate planning. So let's jump in. We're going to do a little presentation I call Estate Planning 101. So this is really just the basics of estate planning and what estate planning can do to support your family during times of incapacity or death. All right, so let's jump right in. Okay, so we're going to talk, like I said, about estate planning 101, kind of the basics of what happens in Louisiana if you don't have a plan, and how that can affect your family, and what we suggest that you do to go ahead and protect the people you care about the most. So first of all, a little bit about me. I grew up in Abbeville, Louisiana. I'm married to my husband, Seth, and together we have 7 children. Our youngest, Marguerite, who you'll see there in the picture on the right, she is autistic and nonverbal. And so when she was diagnosed at about 2 years old, I really started to look at the things that we needed to do to plan for her special needs. And my initial thought was to leave most of our assets to her because she was going to be the one who needed the most support going forward in the future. And then the more I learned about the whole disability special needs law system, I realized that was probably one of the worst things we could have done because it would have eliminated her qualification for some very valuable government programs that would have been available to her with special needs. So it really was a scary thing to realize that I was about to make a huge estate planning mistake for my family. And at that point, I'd already been practicing law about 15 years. And so it was pretty surprising. And so I really started getting into this field a lot more, learning a lot more about estate planning and how to support families in my community to make sure that everything is covered to the best of our ability if should anything happen to either of the parents. And so Marguerite is 9 years old now, and she's doing great. And I'm just loving this area of law and helping families in our community to make sure their loved ones are protected. All right, so before we get started, let's jump into a few definitions here. These are some of the terms you'll hear us talk about throughout the webinar, so I wanted to make sure that you are aware of what these things mean. First of all, the decedent is how we refer to the person who's passed away when we're talking about a succession or a probate matter. A person's estate is everything they own when they die, all of their assets, minus everything that they owe, the debts that they might owe when they die. We're going to talk about a power of attorney, the parties to a power of an attorney are the principal, that's the person giving the power, and the agent, that's the person receiving the power. And a trust, we're going to talk about trusts. A trust is an agreement between the settlor and the trustee. The settlor is the one who creates the trust, who decides what the rules of the trust are going to be, and the trustee who holds and manages an asset or assets for the benefit of the beneficiary. All right, so a few quick definitions there. So we just want to first of all talk about a few common myths about estate planning. First of all, it's important to recognize that all powers that are granted to an individual through a power of attorney extinguish, they go away upon the death of the principal. So when the person who made the power of attorney passes away, the person who was their agent no longer has the authority to act for them. So some people think, oh, I'll be fine. We don't need a will. I have a power of attorney. It goes away. It's extinguished. It becomes null and void upon the death of the principal. Next, it's important to understand that any asset that does not have a beneficiary designation, and what's a beneficiary designation? Any asset that you can leave to a specified beneficiary upon your death. The most common example is life insurance. When you buy a life insurance policy or when one is provided for you by your employer, the first thing they ask you after your name is, who do you want to be your beneficiary? Who will get the proceeds from this policy when you pass away. That is a beneficiary designation. You're designating somebody to receive those assets after you pass away. Similarly, in an annuity or a qualified retirement account, you will have a beneficiary designated. So any asset that does not have a beneficiary designation, for instance, your home, must pass through the probate court to go to the decedent's heirs after they pass away, unless you do more advanced planning. So for someone to inherit a home, for instance, they do have to go to court for that. Or if the succession is small enough, it's possible to do a small succession affidavit, but that's only available under limited circumstances. Most people do end up having to go to court. Next, everyone under the age of 18 must have a financial guardian to hold their assets. And that person is appointed by, it can be appointed by the person who passed away, but it has to be approved by a court, approved by a judge, who could be, in most cases, is a complete stranger to you and your family. There are other options. There's certain types of guardian accounts that can be set up, but if you haven't done any planning at all, then your minor children, if they're under 18, if you have minor children, are in a position where their financial guardian will have to be approved by a complete stranger. Number 4, there is no Louisiana estate tax, no Louisiana inheritance tax anymore. The federal estate tax, we still have that. It currently has an exemption level of $12 million. I think it went up to 12.5 this year for an individual, and around 24 million for a married couple. So that means if you pass away owning less than that amount, you do not have a federal estate tax liability. Now that level does sunset at the end of 2025, and it's going to go back to a level where it's 5 million for an individual, 10 million for a couple, a married couple. But that level, we do expect it to continue to go up as the years go on. Congress tends to move that level up and not down. So that's just kind of an idea. And so you know your assets, and you know whether or not with those exemption levels, you could potentially have an estate tax liability, and the estate tax is anywhere from 45 to 55%. So it's a huge hit for some people who are in that position. Lastly, naming a godparent does not confer the same legal authority as naming a long-term guardian, naming a tutor for your minor children. Some people do think that if they have a godparent named, that godparent is going to be the one who raises your children. They might be the one that you select to raise your children, but unless you have written in your will or in a standalone document who you have selected as your children's guardian, then it will be up to a court. It will be up to a complete stranger to choose who raises your children. That's the way that goes. Okay, moving on. Generally speaking, what is estate planning? Estate planning is a proactive plan that you make about what happens to you if you become incapacitated, and what happens to your loved ones and your assets when you die. An estate plan is legally enforceable, and it allows you to state your wishes and have them honored. Estate planning truly is a plan for life, not just death. Once you've made these choices and made them legally enforceable, you can enjoy your life more fully and with less stress, knowing that you've done all you can for the people you leave behind. All that being said, it's still the case that 68% of adults in the United States do not have any estate planning in place. And if you look at the parents of minor children, that percent is even higher. So kind of check off in your mind if this describes you. Do you not have any estate planning in place, any power of attorney, living will, trust, any of those kinds of things? Or if you do, ask yourself if it's been more than 3 years since your estate plan was reviewed by an attorney. So just to let you know what happens if you have no estate planning in place, if you fail to do any estate planning, rest assured, the state of Louisiana has a plan for you. And it is the default plan of what will happen if you pass away with no will, with no estate planning in place. So we're going to talk about Harry the husband, Winnie the wife, and Allie and Bobby, Kid A and Kid B. So first of all, in Louisiana, for all married couples who have not opted out of the community property regime, either through a prenup or something done after they were married, most property owned, all property owned by spouses is either community or it's separate. So community property, or I should start with separate property, is everything that you owned before you were married, everything that was left to you as an inheritance, everything you inherited, and everything that you and your spouse declare to be your separate property. That's basically the categories of what separate property is. What is community property? It's pretty much everything else. It's everything acquired through the skill, industry, labor, effort of either party. It's everything that was purchased with community funds, and pretty much everything that's acquired. Any property owned by parties during a marriage is presumed to be community. All right, so with that kind of brief overview, you can sort of think in your mind which of your assets are considered community and which are considered separate. So when a person passes away, let's say that Harry, the husband, passes away first. Already, Winnie will own half of the party's community property already because it belongs to her. Each married couple owns one half of the community property in their own right. So half of the party's community property already belongs to the surviving spouse. It already belongs to Winnie. Harry's separate property, one half will go to each of his two children. All of his separate property goes to the children. The separate property does not go to the surviving spouse if you have no will. So since he has two children, it's one half each. They take by heads. And if one of the children had already passed away before Harry and they left children, then their children would stand in their shoes. So if Allie had two children, each of her children would get 1/4. They would take by heads her one half. A lot of math going on here. So we already talked about Winnie's half of the community property. Let's talk about Harry's half of the community property. And this is where things can get a little bit tricky. So Winnie keeps what's called usufruct. She has a usufruct for life or until remarriage of Harry's community property, and the children split the naked ownership of Harry's half. So each child gets 1/4 of the naked ownership of community property. What do those words mean? So usufruct means the usus and fructus. So a person who has a right of usufruct can use an asset and gather the fruits of that asset. So let's say it was a rental house, she would be able to keep the rental income. And that is for her life or until she remarries. And then when upon her death, whatever assets she had usufruct over, those go to the naked owners, to the children. So this usufruct situation, it can work if the parent of the children, I'm sorry, if the surviving spouse is the parent of the children of the spouse who died. But in a blended family, when there's adult children and a second marriage and that kind of thing, conflict can arise. It is possible for conflict to arise. It is also another kind of a confusing thing for out-of-state financing companies, out-of-state banks to really kind of understand the way that we do usufruct here in Louisiana. So a lot of people will write a will just to alter in some way the laws of usufruct to make things easier for their family should something happen to them. But this is what happens if you don't have a will. All right, so let's talk about what would happen if Harry didn't pass away, but if there was an accident and Harry was incapacitated. Let's say he had a traumatic brain injury, was on a ventilator, was really seriously injured. And let's say that Harry had inherited from his parents and had kept in a separate savings account $100,000, and his medical bills are mounting month after month that he's in intensive care. And Winnie really needs to access Harry's separate funds to be able to pay for his care. How can she do that? How can she access that? And then let's say that Winnie is a second wife and Allie and Bobby are Harry's adult children from his first marriage. What if Winnie and the children are disagreeing? Who makes the healthcare choices for Harry? And what are Harry's final wishes as to life support? Organ donation? Did he want to be cremated or buried? What kind of service did he want? So if we don't know the answers to any of these questions, if you don't know the answers to these questions for your family, check off in your head that you need to guarantee that your spouse would know what to do if something happened to you, and that your spouse would also have the authority to do that, would have the legal authority to carry out your wishes if something happened to you. Let's say that Harry and Winnie have minor children in this situation, and they're the minor children of both parties. They're both the biological parents. Let's say they go out for a date night and don't make it home. Who does the babysitter call at that point? Are they near enough to respond? And if they are able to respond, do they have the proper written legal authority to take custody, even temporary custody, of Allie and Bobby? And who takes the children if not? If you don't know the answer to any of these questions, then you need a kids protection plan. This is something we put in place for all of our families with minor children. It's where we name long-term guardians for the children, properly legally name them, and that's who's going to raise your children should something happen to you and your spouse. We also name short-term guardians, and we give these individuals the authority to take temporary possession of your children so that the children will never end up in the care of the state. They'll never end up in the foster care system, even for a short period of time, and they can be with the people they know and trust during that very difficult time. We also make cards for your wallet indicating that you have minor children. This is for first responders to find the phone numbers of who to call and in what order, and that way that ensures that your children will always be with people they know and feel safe with during that difficult time. We do all of this in our kids protection plan, and we offer this to our clients who have minor children. And let's go ahead and say that Harry owns a small business. Ask yourself, who can run it if Harry doesn't make it into work on Monday? And does that person have the ability or the know-how to completely step in his shoes and run his business? Do they have the written legal authority to do so? Will everything that Harry worked so hard to build be sold at fire sale prices 9 months after his death once probate is completed? If you have a small business and don't know the answers to these questions, then it's possible that you need to guarantee the person you choose can run your small business if something happens to you. So let's do something better for this family than just leaving things up to chance. So what we recommend that all adults ages 18 to 108 do, regardless of what their family situation looks like. This is called a will-based plan. And this is where we put in place a last will and testament, which lists where your probatable assets will go. Any asset with a beneficiary designation will pass outside of probate, but this lists where your assets that go through probate will go, who's going to get what. We name a durable financial power of attorney, and this is a person who can make financial and legal choices for you at any time, and that's helpful if you're ever incapacitated. They can step in your shoes and do that for you. We name a healthcare power of attorney. So you not only choose who you want to make healthcare choices for you, but you tell them how you want them to choose in different areas, such as an amputation or a ventilator. These are choices that are hard to make a lot of times for your loved ones. So you're taking that decision off their shoulders and letting them know how you would like them to choose. We also put in place a living will, which has to do with end of life choices, as well as long-term and short-term guardian nominations if you do have minor children. There are some drawbacks to the will-based plan. It is possible that your children could still get all of their inheritance at age 18. I don't know about you, but when I was 18, I didn't always make the best financial choices. I probably would have bought a really nice car, brand new, right off the lot, a whole bunch of things that I didn't really need, and might not have had much left by the time I was, let's say, 25. There's still no oversight over the guardians that you name for your children. Um, it doesn't avoid probate, which can take 9 months or more. It can be costly and time consuming. Some probate matters, some succession matters are handled very quickly with very little effort, but some are more intricate, and that just really depends on your personal situation with your family members and with your particular assets. Every family is different. So it's kind of impossible to say how long a succession can take, but if you've ever dealt with one for a family member, other than naming guardians for their minor children, avoiding probate is the #1 reason why clients come to see me. They've either experienced it firsthand with one of their parents or loved ones dying, or a close friend or loved one went through it and they watched what they had to go through and they had a difficult time. So they want to avoid that with their family. Again, not every succession matter is that difficult, but some certainly can be. And then another drawback to the will-based plan is that it doesn't avoid double probate. Your family has to hire an attorney and open a probate matter in every state where property is owned. So if you own let's just say a condo in Orange Beach and you rent it out, but it is your property, then your family has to open a succession in Alabama to be put in possession of that property, has to hire an attorney there, has to do all of that over again. So that can be avoided, but if you have a will-based plan, this is pretty much what you're dealing with. There are different add-ons to a will-based plan that allows for a testamentary trust. And this is a trust that's created by your will. It only comes into play after you pass away. So it's written out, literally the terms of the trust are written in your last will and testament. That's why we call it a testamentary trust. And with a testamentary trust, you can protect your assets for your minor children or for your adult children if they have a lifestyle impediment, such as a substance abuse problem or a gambling addiction, or they're in a marriage where they have a partner who's not financially trustworthy, or maybe they're not financially trustworthy. You can protect your assets for your children by leaving them in trust. You can leave your assets for your child who has special needs in a special needs trust. It is possible to avoid estate tax if you might have an estate tax obligation, and you can do that with a testamentary trust. Or you can help to make sure that you reduce conflict after your death if you have a blended family and there is that potential for conflict. So all of that can be done with a testamentary trust or with the next thing that we're going to talk about, which protects your family even further. So what we're talking about here is a revocable living trust. So while we just talked about the testamentary trust that you set up through your will and only comes into play after you pass away, a revocable living trust is put into place during your lifetime. Here in Louisiana, we call it an inter vivos trust, inter vivos, between living people during your lifetime. So a revocable living trust, the main goal of it is to avoid probate. So for whatever asset you put in your trust, you can think of a trust as a box. When you set up a trust, when you draft those documents, you've built a box, but it's empty. And as you put assets in the box, you are funding your trust. So for every asset that's in that box, your family does not have to go through the probate process for that asset. So when a trust is properly funded, everything's in the box and you're able to completely avoid probate. But a revocable living trust does require maintenance. It requires you to check in with your estate planning attorney at least once every 3 years, just in case you've purchased an asset and haven't put it in the trust. You might not even realize that something needs to go in the trust. So that's why we send out a questionnaire at least annually to all of our clients, asking if there have been any major life changes. We have a list of about 20 or 30 major life changes that could necessitate an amendment to their estate plan. So we do that. We help our clients with that upkeep, with that maintenance. A revocable living trust also includes incapacity planning. Now, with your power of attorney that we talked about earlier, you can name an individual to act for you in financial and legal situations. But let's say that that person is your spouse and your spouse passes away before you do. And if you're in a situation where you didn't get around to executing another power of attorney, or if you are already at a point where you don't have the mental capacity to enter into a power of attorney anymore because you have Alzheimer's or dementia, something like that, then your revocable living trust can come into play, because what you've done is you're going to name successor trustees. So if you are no longer able to serve as the trustee, then your successor trustee can do that and they can manage your assets for you. So we had talked about those 3 parties to a trust: the settlor, the trustee, and the beneficiary. In a revocable living trust, you and your spouse will serve in all 3 roles. You are the settlor, you are the trustee, and you are the beneficiary during your lifetime. And then after you pass away, you'll have a successor beneficiary who will sort of act like an executor in a will, and they will gather together all of the assets and all of the debts of your estate, and they will handle those, and they will distribute the assets to the successor beneficiaries as you've directed in your trust. So it's another level of incapacity planning. It absolutely saves time, money, and hassle. Somebody has to do all of this work of gathering together what all of your assets are and what all of your debts are. So either your family members can do it for you, your children, your spouse after you die, or you can do it now. It's completely up to you. Some people truly believe, truly feel, I'll be gone. What do I care? What does it matter? And that's one point of view. That's definitely one point of view. But if you have a different point of view, then this might be a viable option for your family. It also helps to avoid double probate. So you can put real estate that you own in another state in your Louisiana revocable living trust. And that way it passes outside of the probate process. Your family doesn't have to hire an attorney in another state to get it passed on to you. You can it'll all be done at the same time as all of your other assets will pass to your beneficiaries. So these are some of the benefits of a revocable living trust. So like I mentioned, the spouses serve in all three roles in a revocable living trust. The tax ID for the revocable living trust is the social security number of one of the parties. It's not a separate entity from the parties. It is the parties. It is the settlers, the spouses who set it up. You do not have to file a separate tax return for a revocable living trust. You do for certain types of irrevocable trusts, but not for a revocable living trust. Like the name says, it's completely revocable, amendable, changeable. It is flexible. If during your lifetime, you and your spouse, for whatever reason, feel you don't want to have it anymore, you can revoke it. You can take all the assets out of it and put it back in your name. Nothing is done that cannot be undone with a revocable living trust. So a lot of people like that flexibility. They might have had experience with some other irrevocable trusts that have caused a lot of trouble because they're irrevocable and not flexible, and life circumstances change and they have to go to court to get permission to do something. With a revocable living trust, you avoid much of that, if not all of it. The trust basically is the spouses. It's the same type of ownership. It's the same thing as the spouses owning that asset. You can still retain your homestead exemption on your primary residence if it's in a revocable living trust. If it's in an irrevocable trust, most other types of trusts you can't. So that's one of the other benefits of a revocable living trust. And then you can still protect your assets for your beneficiaries in trust. So after you die, your assets that are in your revocable living trust can be left to your beneficiaries in their own trust, or you can leave it to them outright if they don't need a trust. If they're older, financially responsible, you're fine with them having it outright, you can do that too. So you have that flexibility, that last bullet point there, with either a will or a revocable living trust, that ability to choose how to leave your assets to your beneficiaries, your heirs after you die. So what do you put in a trust? What do you put in that box that you've built? You can put your home, any real estate really, all of your vehicles, your boats, your bank accounts. That means your checking, savings, money market CDs, your brokerage accounts. So that's if you just went over to your local financial planner, opened up an account and bought AT&T stock with your money that you've already paid taxes on. So we're not talking about qualified retirement accounts. That's a whole nother discussion. That's another PowerPoint. But your straight brokerage accounts that can go in a trust. Your life insurance proceeds, your trust can be the beneficiary of your life insurance. If you have an LLC, if you have a small business, that can go in your trust as well. And that also provides that incapacity planning. It lets your successor trustee or your co-trustee manage that LLC for you if you're ever incapacitated. And then all of your possessions can go in your trust, all of your personal possessions, the contents of your home, your jewelry, artwork, all those kinds of things. Oh, and then another point about the LLC is that this can ensure that if something happens to you, your business can continue to be managed and it can help it to retain its value and not just be sold as an asset sale later on down the road. Okay, so again, same add-on options as there are with the testamentary trust, protecting the assets for minor children, for heirs with lifestyle impediments. You can also make the beneficiary's trust a special needs trust. You can avoid estate taxes, and you can have considerations for a blended family so that her kids get what is hers, his kids get what is his, generally speaking, or some combination thereof. Okay. So a trust Trust-based plan is great for obviously out-of-state property owners for the reasons we mentioned, for blended families because you can kind of more carefully set out who gets what and you can have some oversight on that. Owners of small businesses, people with multiple real estate holdings because it makes it easier. You're doing that heavy lifting before you pass away so that your family doesn't have to do it later on with your succession. It's great for families with minor children or young adults because you can leave those assets in trust for your children and have someone else there. And by avoiding the probate process, your successors, whether it's your surviving spouse or just your children, are put in possession of your assets as soon as your death certificate is available in the privacy of your attorney's office. With a will and a succession, all of that is public record. Everything that goes into succession proceeding is filed in the civil records of the parish where you are domiciled, and it's public record. If you'd like to keep things private, if you're leaving a lot to your kids and you want them protected from financial predators, the trust process is completely private and safe. There are some things that have to be listed in the public record, but the majority of what the assets are that your kids are getting, that is private. And it's done within about a month after the decedent passes away, as opposed to 9 months or more with the probate process. Again, it's impossible to tell exactly how long a probate process will last. Some are shorter, some are longer than 9 months. Yeah, so this is great for anyone who wishes to avoid the time, hassle, and expense of probate, which is great for families with small children because when a young person passes, it's usually a very traumatic event for the family. So this is one less thing that your spouse would have to deal with. All right, so if you're thinking to yourself, I need to avoid probate, protect my children's inheritance, or avoid estate taxes, then one of these trust-based situations might be a good idea for you and your family. So to recap, most attorneys and do-it-yourself estate plans that you might download off the internet, for one thing, might not ever be valid in Louisiana because not all of these online estate planning, legal drafting software tools recognize the distinct differences that we have in Louisiana, such as forced heirship, our community property regime, the way we use usufruct, those kinds of things. They're not recognized. These programmers don't put that much effort into these documents they put there on the internet and sell to people. So if it is even gets to the point where it's valid in Louisiana, it most likely will only address who takes your kids if you pass away. You might be able to name guardians for your children. Your money will still go through the probate court. It'll still be public record. It'll still take as much time as it'll take in the probate court. And it's possible that assets could be missed and lost to the Department of Unclaimed Property. If there is something that your attorney isn't aware of because that wasn't something that they asked in the intake process, then they might not know that it's something that needs to be addressed. What we do for all of our clients is we create a family wealth inventory, which is a huge spreadsheet of all of your assets and all of your liabilities, all of your debts. And we update that with our clients. As often as we check in, like I said, once a year to see if anything needs to be updated. So we have it complete with the name of the financial institution, account numbers, who the beneficiaries are, if there is a beneficiary designation, the approximate values of each of these things. So not only does that help you to estimate if you have an estate tax liability, but we've already done a lot of the work for your family that will have to be done after you pass away. They'll know exactly what you have, where it is, and their attorney will help them, assist them to be put in possession of that. That is a huge step toward making sure that no asset is lost because nobody knew you had it. Maybe you had some cash in a safe deposit box and nobody knew about it. Make sure that nothing is lost to the Department of Unclaimed Property. Most lawyers fail to plan for all scenarios, meaning that their plans may not work when you need it to. So this is how we're different. Your plan will work when you need it to work the most. We try to wrap up most of our estate planning clients within 8 weeks. So from the time of your first consultation, 8 weeks later, generally speaking, you are pretty much done with your estate planning lawyer. At that first consultation, we'll figure out the type of plan that works best for your family. You'll make choices about who's going to serve in different roles. And then 4 weeks later, you'll come back to sign all of the documents that we've drafted in the meantime. And then 4 weeks after that, you'll come back to pick up your complete estate planning binder with all of your signed documents in it, with instructions to anybody who might be helping you with your plan about what to do in each scenario that comes along. So we help to keep our clients on track. Procrastination is probably the biggest enemy to estate planning, because unless you have something coming up like a trip or a surgery, it's really easy to put this on the back burner. So we try to take advantage of the motivation and the momentum that you're feeling right now to get that done and get that wrapped up within about 8 weeks. We only charge flat fees for our estate planning services. We don't ever have any hidden costs later on down the road. Everything is transparent and upfront. If there will be an additional cost for something, such as a recording fee at the courthouse for additional real estate, we let you know that ahead of time. All consultations are included, unlimited consultations are included in that flat fee. So if you have a question 3 years down the road, you can call us and you won't be charged for that. We feel it's so important to keep those lines of communication open, because that's how we ensure that your plan will work for you when you need it to. If you are don't have any barrier to picking up the phone and calling us or sending us an email if something has changed or if you have a question about something. So we make that promise to our clients. We send letters, we call these fiduciary letters, to everyone named in your plan. And what we do is we let them know the roles you've named them to, what their responsibilities are in carrying out that role, whether it's as your financial power of attorney or a potential guardian for your children. And we give them a copy of the documents they will need if that pertains to them. And we let them know they can contact us if they ever have any questions about anything. So if you write an estate plan and it's amazing and it has all this great information in it, and then you stick it in a filing cabinet at home and never tell anybody about it, it's going to be really hard for your family members to know that you even have this thing and to put your plan in place for you when you need it to work, if they don't even know that it exists. So we're going to bring in those people that you love and trust, and we're going to let them know what they need to do to help support you. We also include annual check-ins to see if there have been any major life changes. Like I mentioned, all of that is included in the initial fee. And we create that family wealth inventory to make sure that none of your assets are ever lost to the Department of Unclaimed Property. So if you have any questions, if you'd like to talk about what estate planning would look like for your family, you can go to our website, planwithjulie.com. And right there from our homepage, you can schedule online, you can schedule a free 15-minute phone consultation so that we can talk about whether this is something that is right for your family and what that might look like for your family. Or you can also schedule online if you're ready for your initial consultation. You can do that right from our website. You can also give us a call, or you can shoot me an email. We're located on South College Road, right in the heart of Lafayette, and we serve all parishes in Acadiana, clients in all parishes in Acadiana. Thank you so much for tuning in today. That's all we have for now. I hope you guys have a wonderful rest of the day, and we'd love to speak to you soon. Bye-bye for now.